So we looked at the 3 phases before, right? So I'll just go on what these phases are. So the first phase is having an arbitration agreement, putting it in place, an agreement to arbitrate, either a post-dispute agreement or an arbitration clause. Doesn't matter. That's what you need. You know, your agreement may be there, and you need it after 20 years. Who cares? You know, but it's there. It's there in your contract. It's there in your agreement. Okay, that's the important thing. So once that's the first phase of having a valid arbitration agreement. Once a dispute arises, then you go to arbitration. And you set up your tribunal, the process goes on, and then the tribunal reaches an award, and you have an award. In the award then there's about 60 days in different countries by which to bring annulment proceedings, or known as set-aside proceedings. And once these have elapsed, you have a final award. That's the end of the second stage. Then the third stage is, if you want to enforce the award outside of the seat, you do so through the New York Convention. 3 phases. Okay? So this concerns the first phase. So it's the agreement to arbitrate. That's the cornerstone of arbitration. Without that, you have no right to go to arbitration. If you've got no agreement, you go to litigation. That's it. Unless you have an agreement later on and you decide to go to arbitration. The model law says that which Greece has incorporated, and which effectively general principles of arbitration law, I refer to it, although it's not binding, right? I refer to it because it sets out generally what countries say in their arbitration legislation. So what we need to know is, what is a valid agreement to arbitrate? Okay, this is the first thing. Now, simply because we've said arbitration Paris doesn't mean that this is a valid agreement. It has to be a valid agreement. Okay? So, and remember when we said before, under which of these can we determine what is a valid agreement to arbitrate?
Law of arbitration agreement?
Law of the arbitration clause, right? So the law of the arbitration clause determines what is a valid arbitration agreement. Okay? So we discover these things as we go along, right? Because, but they're important for you to kind of distinguish what applies where. So that's why if you have this list of all these different laws in place, every time you think of something, then subject it to one of these. So Article 7 of the Uncial Model Law says that what is required is an agreement to arbitrate. It doesn't say a contract to arbitrate. An agreement. An agreement is broader than a contract, okay? Because some countries restrict what is a contract. So, for example, if let's say in a country, a contract is not simply an agreement of the parties to do something, but it might also entail, this is in the common law, for example. So you know how the common law makes a contract different from civil law traditions? By requiring what?
No.
It's a principle called considerations, right? And a consideration in English law means that it's not simply sufficient to say that there is an offer and an acceptance, but that there must be a bargain in all this. That there must be a bargain, something that one gains and something that someone has to do. Okay, so I mean, it's not really it's not always hugely practical. It's practical when we have donations, but without valid consideration, there is no contract under English law. So if you have offer and acceptance but without consideration, you don't have a contract in English law, but you have an agreement, but it's not a contract. Okay, now,
could an agreement be oral? Or?
So we have to see, does the law of the arbitration clause allow for an agreement to be oral? In Greek law, it's possible, right?
Yes.
Okay, because you have an offer and acceptance, and that's sufficient. And that within this, that the parties have, there's an implication that the parties agree to be bound by this offer and acceptance.
Emails or written things, etc.
So exchange of emails is an agreement as long as there is evidence of an intention to be bound by these exchanges. Okay, so it's a principle of informality of contracts. Okay, contracts are generally there's a principle of informality in the civil law tradition and also in the common law tradition. So we have oral contracts. That's fine. But of course, you need to prove it. And how would you prove it? By emails or by witnesses. There are some cases where, again, contract law, right? So there are some cases where there is no arbitration agreement as such, but the contract refers to the standard terms and conditions of one of the parties. Okay, like in a bank. So you've got a contract that says a number of things, but there's no arbitration clause in the contract. But the final provision in the contract, in this contract, says the bank's standard terms and conditions apply to this contract. And the standard terms and conditions have an arbitration clause. So one contract refers to another document.
Is this valid?
Yes, because this is known as incorporation by reference. Okay? But of course, in order for this to happen, is that the reference must be very specific, and that and the document must be available. If a document is simply on a website where you click and it says unavailable, and the other party doesn't know where the document is, then it's not a valid incorporation by reference. Okay? It has to be clear to the other party. The other party must be alerted to the fact that there is an arbitration clause in that other document. Okay? Now, less convincing but possible is so-called incorporation by conduct or common usage. So sometimes the parties have an agreement that doesn't have an arbitration clause. But in the last 5 years, they've had 15 contracts almost exactly the same on the same issue, and they all had an arbitration clause. So for some reason this time they decided it's maybe a mistake. There's no arbitration clause. So it's up to the arbitrator to decide if the common practice of these two parties dictates that the arbitration clause was implicit. But the other party will argue, well, listen, no, we specifically omitted it this time because that's what I wanted. So you have to prove. So it's a matter of proof for the party arguing that this was an incorporation by common usage or common conduct. Okay, so that's a matter of proof. So if you can do so. And again, as you mentioned, there might be no arbitration agreement, but one party goes to arbitration. And the other party simply goes on and joins the proceedings and makes no claim that there is no arbitration clause, which there isn't. In this case, there is an implicit waiver in favor of arbitration and against litigation. So if you think that there's no arbitration clause, just go to the tribunal and say there is no arbitration clause. It will end the proceedings. Or you can go to the court and say, listen, they have an arbitration there, but there's no arbitration agreement. Okay? So you can do any of these things. But if you think that... now, the other thing about the arbitration agreement, when it's valid, is what is the scope? That's very important. I think we discussed it slightly. Okay? When an agreement says, you can make it as narrow or as wide as you can. If you want to make it narrow, you can say, any dispute arising from Article X. It's very narrow. You can say, or any dispute arising from this contract. Or in this contract. If you say in this contract and not from the contract, you mean any dispute in the contract. Okay? From the provisions of the contract. So the language that is used, so the ICC or the LCIA, and I'm sure the FAA, has a standard arbitration clause, just to make sure. So clause goes something like this. So if you want to expand it to also encompass actions in tort, then you have to make a broad arbitration clause that says any disputes arising from, under, or out of this contract. Okay? Or out of this contract. And you want to specify, you can even say, just to make it clear, including torts, and so forth. You can make it even more clear in this case. So if you want to have a broad scope to your arbitration agreement. Why? Because if many tribunals have interpreted anything arising in this contract or from this contract as only being limited to contractual disputes and nothing beyond that. Now, inoperable and ineffective arbitration agreements. The parties say, in the event of a dispute, we go to arbitration before the courts of Greece. What is that? So in the event of a dispute, the parties agree to go to arbitration before the courts of Greece.
Invalid.
Before the courts.
Invalid.
it's more ineffective and inoperative. Okay, so what do they mean? So are you discussing arbitration, or are you really going to litigation? So in all those cases, the court will say, well, I don't understand what you're referring to, so I'm inclined to say litigation. Okay. Again, it's a badly drafted clause, so you may lose the chance to go to arbitration. Or the parties may say arbitration in Greece subject to the Paleo-Faliro rules of arbitration, or to Paleo-Faliro institutional arbitration. And you go there and say, well, there's no such thing. There's only a taverna there. Okay.